Now call 124598.
May it please the court, Shauna Miller appears on behalf of defendant appellant Matthew Hutto. We're present and ready for argument.
Please the court, Chris Elsley for the state, present, ready for argument.
May it please the court, Shauna Miller on behalf of defendant appellant Matthew Hutto. Chief Justice Lukert, if I could reserve 2 minutes, keeping on with apparently what's the amount of time for the day.
Hate to break that, right? Yes, certainly. Good 2 minutes is grand.
Right, thank you. May it please the court, this is a bit of a spinoff from the arguments that you just heard on the Richard Showalter case. This matter involves a witness that was actually called in Mr. Showalter's trial, Matthew Douglas Hutto. Mr. Hutto also was charged with similar, if not the same crimes as Mr. Showalter ultimately in his Shawnee County matter 18 CR 1936. He ultimately decided to enter a plea in his case, specifically a guilty plea, and he was sentenced in his matter on May 10th of 2019. Just a few days later, though, he did file a pro se motion, essentially asking the court to for permission to withdraw his plea. The court ultimately denied that, and he appealed that to the court. Ultimately, the Supreme Court issued a decision on July 9th of 2021 that the district court was correct in not allowing him to withdraw his guilty plea. The reason that that is important to this case is that it was on July 13th of 2021, and then a few days later, ultimately on July 16th of 2021, that Mr. Hutto was called to testify as a witness in Mr. Showalter's matter by the state. Mr. Hutto invoked his Fifth Amendment rights to not be compelled to testify in that matter. And ultimately, the court adopted the arguments of the state, which were twofold. One, that the state had offered him use immunity, which ultimately that's not an issue before the court today. But then secondly, the state the state argued, and the court adopted the state's argument, that Mr. Hutto had pled guilty, been sentenced, and their argument was that because the Supreme Court had issued a written decision on July 9th of 2021, that Mr. Hutto no longer had his Fifth Amendment ability to not testify in Mr. Showalter's case. I would point out factually that ultimately the mandate was not issued by the Supreme Court until later, which was August 13th of 2021. Now, the district court judge ultimately, after giving Mr. Hutto the ability to think about it a little bit, possibly purge himself and agree to testify, ultimately imposed a contempt sanction on Mr. Hutto on July 16th of 2021 for 6 months county jail time to run consecutive with the sentence that he ultimately received in his own criminal case. Now, why are we here today? Obviously, we have some cases that can, at least by interpretation, be somewhat contradictory. Specifically, as cited in Mr. Hutto's arguments, was the Smith case that appears from its finding to extend a defendant or a witness's ability to plead the Fifth past the final judgment, and a right to appeal has expired. It's the argument of Mr. Hutto that because, in part, because the mandate had not been issued yet, that his appeal process was not concluded. Also, there were some other various remedies that he could have explored to further the appellant process. And ultimately, it's his argument that he still did have the right to invoke his Fifth Amendment.
Is there a point in time where the right to invoke is not in effect? I mean, this was in between the time we issued the decision and the mandate. If had the mandate been issued, would that have been sufficient? Or is it when if he'd taken cert, is it after that? Is there a period of time that you're taking a position on where the invocation is no longer available.
Well, I will say one thing, that is, two things actually, but one thing is that is one issue that we're asking for clarification of this court from. Because I think there's enough difference in the opinions that does need to be clarified. When does that end? I think that it would have been much more clear if Mr. Hutto's mandate had been issued. I think it would have been much more clear. However, I'm not also going to say that another attorney couldn't come up here and argue that he still had remedies with federal habeas corpus or other things. Now, those are, maybe more civil in nature, but I think it would have been extremely more helpful and a bit more clear in Mr. Hutto's situation in particular if the mandate had also been issued, because that is truly a final issue or order from this court.
Let me ask you, so if you just track the timeline, so plea and then he's convictions and sentence, and at that point in time, they're under our current statutory scheme, did he have a right to appeal?
Yes. Once he had pled guilty and been sentenced, did he have the right
Pursuant to plea agreement?
Yes.
What does the statute not limit the right to appeal for based on plea written on the record?
Limits it significantly, but it does not completely,
Okay.
it does not completely take away any appealable rights.
What would remain appealable at that point in time?
One thing that, for example, that comes to mind would be ineffective assistance of counsel, would be that his attorney was insufficient, and that could be a direct appeal issue, not necessarily, obviously habeas corpus also, but that could be a direct appeal issue. That's just one example that would come to mind.
What about the possibility of innocence or proof of innocence? If it was a DNA case, then does it not end until?
And that was another concern that I had, just in my practice, is that there are situations, unfortunately, that people do enter pleas, even guilty pleas, and are sentenced. And ultimately, as the court suggests through DNA evidence, or even as other evidence is developed, it's found that they're actually innocent. And so that was another concern that I had thought of is, things like that do happen.
So it never ends.
Well, I mean, that is obviously an argument that the state has, that the Fifth Amendment right never ends. I think that, in thinking about this, obviously the Fifth Amendment right to not be required to testify against yourself, to cause yourself self-harm, is probably one of the most important rights that we have, especially in the criminal system. And so it is a very slippery slope as to when does that end and when do we say is enough enough? Does it end when all appeals are exhausted? Does it end when the DNA test results come back? I don't have a great answer to that. I would say, though, in Mr. Hutto's situation in particular, again, I think that mandate would have been an extremely important kind of final order by this court to stop that. But that's a very good concern, because I thought of the same in true innocence type situations.
Did you raise the mandate argument below?
Yes. Yeah. That the mandates did not come out until after he had testified, and that would be a final order from this court. I also raised, obviously, that there was other things that he could have done, such as Supreme Court Rule 706, motion for rehearing, things of that nature. Those things are all still viable options until the mandate's issued.
I should know this already. I don't. Is there U.S. Supreme Court case law that clearly says the Fifth Amendment right ends at some point?
Yes,
Is that
so
just
that
in
would
state
be, I know I wrote it down here. I believe it was at the Mitchell case. I know it starts with an M. I know the state cited it in their brief.
That
Yes, Mitchell versus United States. They specifically say that the privilege does extend to sentencing. What they don't address is that it.
right?
So I think there still could be room for interpretation until it's clarified.
So at least as far as you know, there isn't a decision from the United States Supreme Court that definitively says it's done. You don't have the right any longer.
Not that specifically says that. The closest we get is the
Which is
Mitchell
why-
case.
And I'm presuming here, I presume that's why these arguments all are turning on essentially a string of decisions from this court.
Right, right. And I would concede that the state definitely has a point that some of these opinions can be interpreted different ways. The Smith case could, does it open through appeal? Obviously, the state will likely argue that the Bailey and Soto case distinguish it. So again, ultimately, I think it would be very helpful for this court to be as clear as possible and clarify when is enough enough? When does that Fifth Amendment right truly end as far as being able to be compelled as a witness to testify possibly against yourself?
And I circle back to my earlier question. Now I pulled the statute up under 223602 subsection A. It says no appeal shall be taken by the defendant from a judgment of conviction before a district judge upon a plea of guilty, except that you can then raise a 1507, a post-conviction remedy.
Right. Without having the benefit of having that statute in front of me, I know that even in cases where somebody could appeal and or sentence, for example, another example would be a legal sentence. So I believe that there should be qualifiers, if
That's
not contained in that statute elsewhere, that there is still the ability to appeal, although they are significantly limited, obviously.
well, that wouldn't necessarily be a direct appeal. That's a motion to correct an illegal sentence, sort of a collateral attack. I mean, it's a separate vehicle, I guess.
I mean, yes.
Challenge. Okay. I was just wondering if there's a way we can reconcile Anderson and the other cases that, at that point in time, there actually was, there was no direct appeal right at that point in time. And you see how that would create some consistency with that general rule.
Yes, absolutely. Absolutely. I guess another option to throw out there is the state always has the option of offering immunity, which they did partially in this case. They just didn't offer the full immunity, which I think ultimately was fatal in this case. The state always does have the immunity option if they do it appropriately. And so maybe this court keeps the Fifth Amendment available at all times until or unless they're offered immunity. That's just another way to throw that out there, because I do agree that it's a slippery slope on when does that Fifth Amendment truly end in the appeal process? Is it sentencing? Is that a bright line rule that we really want to impose on people? Any other questions? All right, I'm going to turn it over to the state at this point. Thank you.
It please the court, Chris Elsliger, appearing on behalf of the state. Opposing counsel prefaced my argument fairly well there. We have the reason we're here, we have this kind of one odd case that seems to, whereas most of the case law says that the Fifth Amendment right ends when, and this is in the context of when a person has pled. So this person has pled guilty. So already incriminated themselves in open court, right? Pled guilty and been sentenced. The case law all tends to supports the position that after sentencing, that's when the Fifth Amendment right terminates, unless before sentencing, the person had filed a motion to withdraw the plea. That didn't happen in this case. He did file a motion to withdraw the plea after sentencing, and that's what the appeal was about, which is how he was able to appeal. Justice Wall, to get to your question, he wouldn't have been able to appeal from the plea, but he filed a motion to withdraw a plea after sentencing. That was denied, and he appealed that denial. But we've got this one case, State v. Smith, where just some inartful language, because it wasn't really the Fifth Amendment. This type of situation wasn't really at the crux of the case. But the court said the Fifth Amendment privilege against self-incrimination extends until there's a final judgment in the case and a right to appeal has expired. And it's kind of ambiguous. I mean, what that actually means. But the case with that, in that case, you had something like 5 co-defendants who had been tried together, and they were arguing on appeal that their case should have been severed. And part of the reason they were arguing that severability was because they would have been able to call one of the other co-defendants. And so this kind of came up as a tangential part of that. The court was saying, well, it wouldn't have mattered because they could have still claimed the fifth. In fact, nobody in that case had pled or anything at that point in time. So that language, it wasn't, again, it wasn't even really the issue on point in Smith. And it was sort of on a secondary issue. When you look at the cases that actually address this directly, like State v. Longobardi, which is kind of what I opened with in the brief. I mean, this court said that once a plea of guilty has been regularly accepted by the court and no motion is made to withdraw it, the Fifth Amendment privilege against self-incrimination ends after sentence is imposed. And it spoke directly to, when it talks about a motion to withdraw, before sentencing.
Counsel, I guess my question is, do we even have to distinguish Smith? Because the way it looks to me is in a case like this, when you have a plea that's entered and sentence is imposed without objection, the right to appeal has expired because there is no statutory right to appeal.
That is a perfectly reasonable way to read it. Like I said, the language in Smith, like I said, is it's a little ambiguous what it means. And that's how, I mean, and that was, but that's what was raised by opposing counsel in the brief, was that this language in Smith, because you can read it, could read it more broadly. But you're right. I mean, that's an entirely possibly correct way to read Smith. It's just that Smith lends itself to other interpretations as well. I mean, you could simply clarify that that's what Smith meant, because certainly cases that followed Smith, as she pointed out, Soto and Bailey. I think Bailey was almost this exact situation, and the Bailey court said that, yeah, it ends when he's sentenced, and that's it. Otherwise, I mean, the other. If you go the other way, then you've got this open-ended, well, they could file a 1507, and they could file federal habeas, and sometime far down the line, years from now, they might get their, no matter how remote the chances, they might get their conviction overturned, and all of a sudden they want their Fifth Amendment right back. And I think, as the Court of Appeals below pointed out, you can't have this, you would have this sort of Fifth Amendment right being extinguished and then reestablished and extinguished. It just doesn't make any sense. In the case where a person has pled guilty and been sentenced, the case law pretty clearly says that's the end of the Fifth Amendment right. It's just we have this.
Well, that's what some of the state case law may say. Do you know if there's U.S. Supreme Court case law that says it?
Yeah, well, we cited Mitchell v. United States, and
I am also looking at Mitchell.
Yeah, and it kind of suffers from the same problem because it has that little ambiguity there.
Yeah, I'm looking specifically, and I wanted to ask you about this line, that the U.S. Supreme Court's guiding light seems to be when they say, if no adverse consequences could be visited upon the convicted person by reason of further testimony, then there's no further incrimination to be. So if that were the rule, seemed to me that would cut in favor of the defendant here.
Well, but the U.S. Supreme Court went on to say the principle applies to cases in which the sentence has been fixed. And then comes the little bit of ambiguity, and the judgment of conviction has become final. Then it's, well, what does final mean? But the federal courts, the lower federal courts, I think have pretty much universally interpreted that to mean just what I'm arguing now, that once the sentence has been imposed, that's when the Fifth Amendment right ends.
As opposed to the sort of more amorphous, no adverse consequences.
Yeah, because I think you have to read in Mitchell, they kind of qualified what they meant by no adverse consequences is conviction, sentence, then we're done. Because the possibility sometime down the road of an appeal succeeding or some collateral, that's too amorphous. And then
is it too amorphous in this case where post-sentencing, pretty contemporaneous with post-sentencing, there's a motion filed to set aside the plea. And I think the standard after post-sentencing is manifest injustice. It's hardly a standard that ever gets met. But what if it did get met and he was compelled to testify? Wouldn't that be an adverse consequence? I mean, I know it's speculative, I know, but it's possible that plea withdrawal, that the burden could be met of manifest injustice. And what is that something where the line should be drawn? Or?
I think the line should be drawn as the court has said at entry of plea and sentencing, because just for as a practical matter, otherwise the Fifth Amendment right is never extinguished. I mean, it would just.
I understand that too. Yeah,
I mean, it just seems that there, at some point, some practicality has to enter into the.
What's so
equation.
bad? What's so awful about that? That the right would not,
Well, it makes no
Quote,
sense
unquote,
because
thing.
if he said he's gone into open court and pled guilty, so I did this. I mean, at that point, I mean, he's incriminated himself. What more adverse consequence could happen than that? And then you're saying,
these-
well, but we're, even though he said that, because it's possible sometime down the line that might, I mean, that statement in open court, his incriminating statement made in open court, I don't know, I mean, it doesn't make any sense that he could, that he's made that statement in open court and yet he retains the right to later say, oh no, I can't testify about that because I might incriminate myself. I was like, dude, you already did that. You incriminated yourself in open
well,
court.
so long as he has available to him a legal pathway
But there's always,
up and
there's always, I mean, you could, like I said, you could stretch that on into multiple successive 1507s and federal habeas petitions ad nauseum, and it never ends. I mean, at some point we have to be intellectually honest and recognize that we need a practical rule.
well, the Fifth Amendment is the opposite of practicality. That's the whole point. It says the government can't coerce someone to be a witness against themselves. That's, I mean, if you wanted
well, that's,
practicality, you
but
just
once
go back.
once the man has gone into open court and said, I did it, I mean, I think at that point, he accepts the fact that his right is going to terminate. I mean, it's a trade-off. And with all,
Talking
we do
about
that
it
with,
almost like a waiver.
it is a waiver. I mean, we do that with all the constitutional rights, that none of them are absolute. There's always some limitation generated by practical necessity. There are no further questions, and I would simply ask to from the lower court. Thank you.
May it please the court, just briefly, unless there's more questions, I want to follow up on the question I believe that was asked about the Mitchell case on no adverse consequences. And I think that's a very valid point in that for the fact that he can't be sentenced again doesn't mean that there's not going to be other collateral adverse consequences. Should somebody be compelled to testify against their Fifth Amendment right, should they deem that appropriate. Additionally, another issue was brought up, I think, about, while it's extraordinarily uncommon for somebody to show manifest injustice after sentencing, it does happen. Go back to the DNA example, or, some sort of horrendous other fact scenario, it is possible. And again, somebody being compelled to testify and not be allowed their right to invoke their Fifth Amendment rights can be an adverse consequence, although it may be rare, it is possible.
Well, aside from the realm of the possible and the speculative and tests that may or may not be developed later, what about the waiver argument? Since he has done the ultimate self-incrimination by pleading guilty, has he waived his Fifth Amendment right?
That was a very interesting argument brought up by the state. If that's something that the court's going to find, perhaps that's something that should be added to the list of questions at an arraignment. When somebody is entering a plea, that they understand that they're waiving their Fifth Amendment right to assert their innocence in the future. I think,
Isn't
Fifth
that
Amendment
obvious?
right,
I mean,
sorry.
Isn't it obvious that they're not exercising their Fifth Amendment right in the
No,
ultimate way?
No, I would say in dealing with most criminal defendants, absolutely not. That's not obvious. You would need to be extraordinarily clear about that. I can't tell you how many clients have pled guilty and still assert their innocence. I mean, we all know that happens, that people plead guilty and still assert their innocence. So I think it would need to be spelled out very clearly and very carefully if that's what the standard that we're going to hold criminal defendants to, that if you're going to plead guilty, you need to understand you can be called as a witness to testify as to what you did or did not do in this matter. Again, the Fifth Amendment right is one of the most important, if not right at the top of the important amendments that we have to not incriminate ourselves. And I think we need to be very careful and very carefully spell that out, not only for attorneys such as myself in the state that are dealing with this issue before the court today, but also for our folks that find themselves in the criminal system. So, any other questions? Thank you very much.
Thank you. Thank you to both counsel for your arguments this morning. The court is now in recess until 9 a.m. tomorrow morning.